The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Good afternoon. We have 3 cases that will be submitted. Those cases are State of Iowa versus Keegan Craig Smith, Troy Williams versus State of Iowa, and State of Iowa versus Rodney Hanneman. The last case, Hanneman, will now be submitted to the court without oral argument, and we'll hear first the arguments in State versus Smith. Mr. Lindholm.
Good afternoon. May it please the court, counsel. I'm here today on behalf of Mr. Keegan Smith. This court is presented us with an opportunity to give some argument and some clarity to Iowa Code Section 321J 11, which allows for a person who has submitted to a state-administered chemical test the opportunity to get independent chemical testing completed. And before I jump into the legal argument, I'd like to take a minute just to refresh for the court the actual statements that were made in this particular case. And I do that because the state has argued in a portion of their brief that Officer Dara had told Mr. Smith at some point in time that he would take him to get independent testing done. That statement came from Officer Dara at his suppression hearing, from his recollection. When we go back and look at the video in this case, that statement was never made. And I think that's a very important distinction for this court, hence my reasoning for giving you the actual statements. Mr. Smith, prior to submitting to the data master, said, "If I refuse, then do you take me to the hospital to take my blood?" Officer Dara, "No, we can give you another chemical test if you want, but that will be on your dime." Mr. Smith, a few minutes later, "So if I refuse, what happens? Are we going to the hospital to do a piss test or what?" Officer Dara's response, "No, we don't need to go to the hospital, but if you want to do a blood test, that's up to you." This appeal presents 3 different scenarios and 3 different opportunities for this court to provide some clarity on 321J11. The first one is addressing the sufficiency of those statements and whether or not those statements were sufficient to trigger Mr. Smith's right to independent testing. The second opportunity is to determine whether, in fact, his statements were properly timed in order to trigger his right under 321J11. And then finally, if, in fact, those statements were sufficient and properly timed, the duty upon which the officer has, once Mr. Smith has invoked that right, what is he to do? As it relates to the sufficiency of the request, we know from State versus Lukens that statements need to be reasonably and liberally construed so that anything that could reasonably be interpreted by the officer to be an exercise or an attempt to exercise right to independent testing should be construed as such.
Here's where I'm a little confused. The quotations that you gave, the answers that the officer gave were accurate, and yet your client never asked for the additional test. Am I right?
The answers were not accurate. If you look at Officer Dara's first response, it says, "No, we can give you another chemical test." We is not independent. So I disagree that his answers were correct, at least in that respect.
Well, what about the first part of his inquiry was, "If I refuse the breath test, are you then going to take me to the hospital for a blood test?" What do we do with the statement, "If I refuse"?
I don't think the statement, "if I refuse," has any bearing on this whatsoever. And if it does...
Well, the officer's asking him to take a breath test.
Correct.
And he's explaining to him the consequences of failing to take a breath test. And he says, "If I refuse, are you going to take me to the hospital for a blood test?" How is that a request for an independent chemical test?
Well, you have to remember here that there was at least 5 or 6 different times in which Mr. Smith brought up a blood test, okay? That's first and foremost. Second of all, he is asking what happens if I refuse. I don't think that goes to, has anything to do. I mean, it's a conditional element in that statement, right? Similar to the conditional elements that this court all had to address in State versus Effler. Well, Effler rationale was rejected in Hicks and applied in Lukens, so that any statements that can reasonably be construed should be that.
Well, in Lucan, it was, I want to retest. I want to reblow.
Sure.
And we said, well, that can reasonably be interpreted as a request for another test, which falls right into what we're talking about. But if Smith would have said, instead of saying, if I refuse, are you going to take me to the hospital? If he would have said, if I take the breath test that you're requesting, are you then going to take me to the hospital for a blood test? Now, that would be a request for an independent
Certainly,
medical test.
I think you have to look at this. I mean, it's hard to put ourselves in Mr. Smith's shoes. And one of the explanations I guess I can provide to you, or one reasonable, plausible thing for you all to consider, is that when he says, if I refuse, he's wanting to know, do I have the ability to go do something different than what the state is asking me to do? The other consideration is that he's simply just trying to get as much information as he possibly can to make an informed decision about whether or not he should submit to the state test. And so I don't read, and I don't think this court should read too much into his statement if I refuse. Again, any statement that could be reasonably construed, and here we have Mr. Smith talking about going to a hospital, an entity that's different and separate from the state of Iowa or the officer, and we're asking for a type of testing that is separate and distinct from the type of test that the officer requested or was requesting. I think that goes to the heart of the independency of where Mr. Smith was. A test by somebody different and a substance that is different than what the state is requesting.
Do any of those statements you've talked about not get proceeded with if I refuse?
I'm not sure I understand your question.
You said the defendant made those statements 5 or 6 times. Was each time the preface of that sentence, if I refuse?
Are you talking about the statements at the scene?
The statements you're saying your client 5 or 6 times asked for an independent blood test
Okay,
or test. And we've brought up some examples where it seems to have been preceded always with, if I refuse, blah, blah, blah. I'm just wondering, do you have any of those requests where he didn't precede it with, if I refuse?
We don't know the exact substance of the statements that were made at the scene, so I can't answer that question. It's not in the record as to whether or not all of them were that way. The ones at the station were. They had that preface to it, if I refuse.
Mr. Lindholm, let me you asked earlier, or you emphasized earlier, the officer's response was, no, we can give you another chemical test. If you want, it'll be on your dime. What's the significance of that statement?
Well, Justice Mansfield asked if his response was correct, and I don't think that is a correct response. When he is saying we can give you another type of test, the response there is not independent in nature. In other words, the officer's not saying you can go get an independent test done. He's saying we'll be the one that administers that test to you.
Isn't that kind of, parsing words? I mean, this is a conversation between people, not, a dialogue in a judicial opinion or something. I mean, the officer says it'll be on your dime or whatever, it'll be your expense. So I think, doesn't that convey to the person who's in detention that they can pick they can do the test and they can control it and so forth and so on?
It could be interpreted that way. It could also be interpreted that if you want an independent test, we're the ones that do it, and you're going to pay us to do it.
Then it's not an independent test. I mean, I agree with you in a sense there. What is it? I know that we've sort of crossed this bridge in Lukens, but don't you agree that the right to have an independent test, it doesn't secure a right that really is at the same level as 804.20, does it? 804.20 is meant to protect the right to counsel, the right against self-incrimination. This right to a second test we're talking about here is just to help ensure the accuracy of what's been done, right?
Well, I respectfully disagree. I think that just like 804.20, this statute also has constitutional undertones to it, and those constitutional undertones are the right to present a defense and gather your own evidence to present that defense. We know from Birchfield that there's a big difference in significance between a urine test versus a breath test and a blood test in terms of accuracy and reliability. So, no, I think this is just as important as the statutory right under Iowa Code Section 804.20 for that reason. And I think this court has equated the significance of 321J11 to 804.20 through Lukens. And so, no, I think that they are two separate and distinct rights that have the same importance for somebody in Mr. Smith's position. So as it relates to the sufficiency, I think we've gotten those arguments out of the way. The timing, I would like to address the timing a little bit. We know from the holding in Ginsburg that somebody who asks to have an independent test done prior to submitting to the test should be informed about their right to independent testing. And in this particular case, that's exactly what happened. There was an inquiry by Mr. Smith about getting a different type of test at a different location than where he currently was. The fact that that request occurred prior to Mr. Smith submitting to the data master really should have no implication in terms of whether or not he invoked that right. If, in fact, the state's position is correct that Mr. Smith can only trigger his right to independent testing after he submits to the state administered test, what is an officer supposed to do when somebody like Mr. Smith asks, can I get a blood test done? Is he supposed to stand silent? Is he supposed to tell him no? Clarity. We want clarity of the law. Justice Waterman in the Lukens dissent talked about that. We want people to have clarity. We want them to know and understand what they're capable of doing. So I have to ask, what is so unreasonable about the officer telling somebody, yes, you get an independent test. We will take you to do it. You can make arrangements to do it, but you're entitled to get that done after you submit to our test.
Well, there certainly isn't any statutory language that explains how the opportunity for an independent test is to be conducted, is there?
Not within the statutes, but if you look at the holding in State versus Wooten, and you apply that holding, and that holding said that a request made an hour after the person submits to the test is too late, and you take the state's position that you can only trigger the right after you submit to the test, what kind of window is that for that person to exercise the right? It's a very small window.
Well, it's an interesting question. Then, does the statute draw any distinction then between requesting that a sample be withdrawn for testing? I mean, a blood test and a urine test is tested days later. The important thing, I think, is that the request is all about is asking that there be some sort of specimen or some sort of sample taken so that it can be preserved for independent testing on the defendant's dime at some later time. Isn't that what this statute's really all about?
I would agree that that's what the statute is about. It is about giving the arrestee the opportunity to have a sample preserved for testing later on down the road. You are correct in that there is no language in 321J11 saying, here's the start of when this right can attach. Here's the end of when this right can attach. But isn't it, we got to look at the reasonableness here, and what are we trying to accomplish? We're wanting to give arrestees and officers an opportunity to know what their duty is to trigger this right and to help the person enforce this right. So in this particular case, if this court says Mr. Smith's timing of his request was not sufficient because it was prior to the administration of the test, then it comes back to, okay, well, what duty are you going to then tell the officer he has in that situation? Is it nothing? He stands mute? Or is it simply to say, no, you don't have that right? I mean, again, in Lukens, this court recognized that people may be tangentially aware of their right to independent testing, but not really know how to go about doing it. What's so wrong with putting that burden on the officer to say, here's how it works? We did it with 80420. Why should this case and this situation be any different?
What if the officer, instead of saying, we can do another test, but it'll be at your expense or something, what if he had said, you can have another test, but it'll be at your expense? Does that then, would that end the case? Would that mean that, and eliminate your argument of a statutory violation?
Are you saying if the officer makes that statement before Mr. Smith would have submitted to the test? Well, that's...
No, when the question was asked, if the officer had said that, had used you instead of we.
No, I don't think that fulfills the officer's obligation. It fulfills his obligation to inform him as to what the right is and how to exercise that right, okay? But once Mr. Smith submits to the test, then I still think it's incumbent on the officer to say, do you want to do that? I mean,
In every case?
What's wrong with that? Yes, I think in every case, yes. Because in every case where there's a request. Maybe I'm not tracking your question correctly, but I think any case where a statement can be reasonably construed to be an attempt to exercise the independent test.
In any case where the detainee asks about sort of another test or testing or another type of test, then the question needs to be answered accurately. And then after the sample the data master is done, the officer has to say, now, to follow up on that, do you want an independent test at your expense? Is that what?
Well, if we don't require that rule, then you're refusing to acknowledge the disparity between the arrestee and the officer, like we did in Hicks in an 80420 context. You put the affirmative obligation on the officer in Hicks, recognizing the disparity in power between the arrestee and the officer. So yeah, I don't think that's overly burdensome, and I don't understand why that would somehow thwart the purpose of 321J to put that burden on the officer.
Thank you, Mr. Lindeman. You'll have time for rebuttal.
Thank you.
Mr. Miller.
May it please the court, counsel. My name is Zach Miller, and I represent the state of Iowa. This court should affirm Mr. Smith's conviction for 4 reasons. He didn't adequately request a test. He did so too soon. Officer Dara complied with his duties under the statute, and any error was harmless. Starting with Mr. Smith's request, as Justice Christensen asked, every time he made any statement about testing, it was prefaced by if I refuse or if I deny. And it was in the context of a conversation of trying to understand the information in the informed consent context of what would happen. And so there was never a request for any test. It was a conversation to try to find out, what happens if I do this, if I do that. There was never any indication that he actually wanted another test. And it stands in stark contrast to Lukens, where immediately after the data master, the detainee or arrestee had asked for a reblow in the context of being bleeding and thinking that the test results were inaccurate. So we have a very different factual context here that warrants a different outcome. So because Mr. Smith never invoked his right to independent testing, this court should affirm his conviction. Turning to the timing component, there's no right to independent testing until you've completed the state's test. Mr. Smith had not completed the state's test at any point when he asked about breath or urine tests or going to the hospital. And because he didn't yet have that right, he couldn't invoke it.
Well, Mr. Miller, wouldn't it be actually to the state's benefit to know before they select which test they're going to request from the defendant, that they know whether or not the defendant is going to be requesting an independent test as well? For instance, in this case, the officer, as I think is customary, as most of them will first offer a breath test. It's right there in the station. It's easy. It's reliable. Everything, but we don't have there's no sample preserved for later testing. So we might as well know up front if the defendant is going to want an independent test, because if the defendant wants the independent test, then the officers are going to end up taking him or her to the hospital for a blood test or a urine test, correct?
I don't think so, Your Honor, because there's no obligation on the state to take anyone to the hospital or facilitate the testing. In fact, the statute puts the onus on the person who is being investigated.
Well, how is a defendant taken into custody and offered only a breath test ever going to be able to achieve this opportunity to have an independent chemical test?
I guess one example would be if they were able to make phone calls, which Mr. Smith was offered here. They could call a doctor, a nurse, a phlebotomist, and then they could have that person come to the station and get the testing. Now, I realize that might not always be easy, but the statute does contemplate that when it says that if for whatever reason, person fails to get the testing or is unable to, then the state's test isn't suppressed.
Well, wouldn't it be much more practical, if for the officers just to say, okay, we're not going to do the breath test, but we'll take you to the hospital and we'll do a urine or blood test. Then the state gets their sample, defendant gets his or her sample, and everything's complied with.
I can see why that would look appealing, but I don't actually think it's that practical. There's a lot of places in Iowa that are relatively small. They don't have large numbers of officers on duty late at night. That might tie up the entire police force for the entire evening if you have to drive who knows how far to find someone who will draw blood. So I don't really think that it's practical, but more importantly, the statutory language doesn't demand it. We might think that's reasonable, but the legislature chose to enact a different statutory scheme. It required the detainee to have the tests done. It's their duty to do it, their obligation to do it, I guess I should say.
You're going
Are you
to
suggesting then that the statute must be interpreted to simply mean that if there is a specimen taken at the request of the state, that specimen is available to the defendant for some later testing under whatever circumstance the defendant finds himself or herself in?
I don't think the statute would require that. Certainly the state provides the breath test results to the person, the defendant in this case. If the person had blood withdrawn or urine and the testing wasn't done until later on that sample, but it was preserved in a way that didn't make it unreliable, I don't think that the state could try to exclude the evidence on that basis.
But if there's a breath test, there's no sample preserved. There's no independent testing available for a breath test, correct?
True. Yeah.
But the other two forms of testing, there would be something preserved. So my question was, are you suggesting that the statutory language of 321J.11, which gives the defendant the right to have this independent test, that would not apply to a breath test situation, but only blood and urine testing as requested by the state?
No, if I understand your question, I don't think so. No matter what test the state gives the defendant, they still have the right to independent testing. It's just that the statute puts the burden on them to get that testing. Now, the state can't frustrate that right. They can't lock them in a cell and prevent them from making any calls, or if someone shows up, keep them out of the station from collecting the sample to test. But the state doesn't have any obligation to facilitate testing on behalf.
Correct me if I'm wrong. When we're talking about these cases, some of the statements were made during the interaction, I assume, on the road, maybe a little bit later, at different stages of the process. And would I be correct that many times what the eventual request is changes perhaps from moment to moment based on the officer's observations? Maybe they decide all of a sudden, I want urine. I don't want breath for whatever reason. So that's a moving target. Would I be correct that a decision's not made till sometimes the last minute by the officer?
Certainly, there's no obligation to decide early. I think that's
And
right.
if he or she asks for urine, and if somebody wants their own independent test, their only choices are, of course, not the breath, but they can do blood or urine, correct? On their own, on their own dime.
Yep.
And if the state would decide they want urine on their own, independent could be blood or urine. Is that correct?
Yeah, I think that the defendant can do
Blood or urine, no matter what the
Right.
state does, correct?
right.
But of course, they can't do breath because the machine is for the state.
Right. I don't think that the state has to use their machine. If the defendant found a machine to test their breath, I think they could do that under the statute, but the state doesn't have an obligation to let them use the state's
Okay.
machine.
Thank you.
So because he invoked that right prematurely, that's another basis to affirm the district court. And as I was kind of talking about, Officer Dara complied with any duty he had. He told Mr. Smith about the testing, that he was asking for breath, that Mr. Smith would be able to do independent testing later. He offered to let him make phone calls even after the 80420 calls had been completed.
You know, let me probe a little bit on your statement. He made it too soon, and you had earlier said he didn't invoke it because he conditioned it on if I refuse the test. And if he refuses, he doesn't have the right. It's only after he takes the breath test. What if he had said, if I take the breath test, then I want a blood test? But then he doesn't repeat that statement, that request, after he takes the breath test. Has he invoked it?
No, Your Honor. So up until the point of the state's test, if a person makes a statement that can reasonably be construed as a request for independent testing, the officers have a duty to explain that right to testing. I think that's from Ginsburg. And then the onus is on the detainee afterwards to actually request the independent testing once they've completed the state's test and their right.
So if he says, I'll take the test, but if I take the test, I want a blood test. Then he takes the test, but he's silent. He loses.
I think that under the statute that's true. You might have some kind of argument that there was an agreement between the officer and the detainee that he could say the officer violated that agreement between them, that he relied on it to do the testing. I don't know, but I don't believe under the statute that would be a problem.
What about, I'm not saying this statute necessarily requires this, but what about just adding to the implied consent advisory the first sentence from J11, the person may have an independent chemical test or test administered at the person's own expense, in addition to any administered at the direction of a peace officer? What if that were just added? And that seems to me to address Mr. Lindholm's issue, at least in the future. Why would that be so impractical?
I don't think that it's impractical, but the question is whether there was a statutory violation warranting suppression, and the answer is that there wasn't. I think that would be a practical thing to do, but it's not required by the statute. And so there was no violation here because he didn't have an obligation to.
So what's the remedy if he does everything right? He takes the breath test, says, I want a blood test now, and the cop inaccurately says, you don't have any right to a blood test, so no. Is there suppression?
This court had suppressed the evidence in Lukens. I think that the answer is that there is suppression under this court's precedent because the officer in that situation would have frustrated his right to testing after it had already accrued under the statute.
Is there overwhelming evidence of guilt here that this issue, we don't have to decide it?
I think that there is. The district court said that it found beyond a reasonable doubt that Mr. Smith both blew over .08 and operated under the influence. The truck smelled of alcohol. He smelled of alcohol. He had bloodshot, watery eyes, slurred his speech. He didn't remember giving his ID to the officer. He failed every field sobriety test. In the video at the station, he seemed upset. He was hitting himself in the head. I think that shows his consciousness of guilt. He admitted to drinking 54 ounces of beer and said he shouldn't have come to pick people up in the state he was in. So I do think that that was overwhelming evidence that would render any error harmless.
Isn't that kind of hard to do? I mean, it was a trial on the minutes, so presumably if suppression had been granted, there wouldn't have been a trial on the minutes. It would have been a regular trial of some kind, right?
I don't know, probably, but I guess that's a hypothetical that didn't happen. I think that here it's okay because we know that the court found both beyond a reasonable doubt, and it also only mentioned the breath test in the context of saying he blew a .188 over .08. In its order, it didn't tie that to the other facts of guilt. Now, it didn't explicitly say that it didn't use that, but I think because it was tethered to the .08 alternative, it didn't negatively impact his rights such that you can't find harmless error. So for these reasons and all those in the state's brief, the state would ask that this court affirm Mr. Smith's conviction. Thank you.
Mr. Miller, thank you as well. Mr. Lindholm, you may present your rebuttal.
Thank you. We want arrestees to make knowing and informed decisions, both whether they are going to consent to testing or whether they're going to refuse testing. If an arrestee has a question about getting another type of test done, there is no reason not to require the officer to inform them how that procedure works and follow through to see if they want to partake in that procedure. It's a simple rule. It's an easy rule. It's a rule that had we originally done what we've done now with 80420, we wouldn't have had all that litigation leading up to it. And the state has not advanced, nor do I think they can advance any reason as to why this would be detrimental to them or their officer. I think
At some point, are we making the arresting officer a lawyer for the person he's arresting? I mean, how often do you have to follow up? Sir, earlier, at roadside, you asked some questions about a blood test. Do you want one now? I mean, do you have to follow up if the guy doesn't renew his request or even make an explicit request?
Well, I think so. We do it in the Miranda context. I don't see how this is any different.
Here,
What if
again, you're
it's-
equating the right to counsel, the constitutional right to counsel, and my dissent in Lucan's push back at that idea of blurring together statutory right to a second test with the 80420 right to counsel. I think the right to counsel is more important.
Well, yes and no. I mean, if there is, in fact, constitutional undertones to this statute, like the right to present a defense and the right to gather evidence in your own defense, I think the two are the same.
What if you have two different people? I mean, what if the person who made the arrest on the field is not the person doing the data master?
Shared knowledge doctrine. If it applies one way, it should apply both ways.
So you're saying that even whoever administers the data master has to assume that there was some discussion earlier where the issue of a second test was raised. Is that kind of the gist of it?
It is, because Mr. Smith had another officer been at the scene and investigated him and had all of this evidence of intoxication at the scene that ultimately led him to invoke implied consent, hands him off to another officer at the station. That officer gets the benefit of the shared knowledge doctrine. The state gets the benefit of the shared knowledge doctrine so that they can invoke implied consent. Why shouldn't the converse be true? Additionally, if we talk about this narrow window, that if Mr. Smith can only exercise his right after he submits to the test, but we know an hour afterwards is too long, oftentimes officers are handing people over to jail staff immediately. So yeah, I think in those situations that is not unreasonable. I also want to address the harmless error question just briefly. I would note for the court that I specifically stipulated only to a trial on the minutes on the breath test alternative under 321J.2. I did not stipulate to the under the influence alternative. To the extent that the court found guilt based on the under the influence alternative, I don't think the court was authorized to do that because it goes beyond Mr. Smith's stipulation to the trial on the on the minutes. With that, unless there's any other questions, I'd rest. Thank you.
Mr. Lindholm, thank you as well, and Mr. Miller, thank you again. The case of State versus Smith is now then submitted, and we'll next hear the arguments in Williams versus the State.